Good afternoon, everyone. This is Paul Russo from CUNY School of Professional Studies. I'd like to welcome you to this afternoon's webinar, Unauthorized Practice of Law. Joining us today, our panelists are Tom Shea, Director of Training and Technical Assistance from the New York Immigration Coalition, and Daisy Mejia, Attorney in Charge from the Manhattan DA's Office Immigrant Affairs Program. The webinar today is brought to you again by our colleagues at Citizenship Now and the School of Professional Studies. The web addresses for both are shown on the screen. For Citizenship Now, it's www.cuny.edu/citizenshipnow. For the School of Professional Studies, it's www.sps.cuny.edu. Be sure to take a look at some of the volunteer opportunities at Citizenship Now and the certificate program at CUNY School of Professional Studies. I'd like to turn it over to our presenter now, Daisy Mejia. Daisy?
Thank you so much for giving me the opportunity to be here. It's a real honor. I also want to thank CUNY for this opportunity. The focus of the presentation is to discuss what is the unauthorized practice of law. But I would like to begin by first giving you an overview of the presentation that I'm about to do. And as part of that overview, I just want to tell you a little bit about myself and essentially what I do. Then I want to talk to you about the statistics, and hopefully that will inform the importance of what we are about to learn here. And then we're going to discuss New York State and New York City law, as well as relevant federal regulations. I'm also going to give you some tips for people on how to prevent victimization when it comes to the unauthorized practice of law, and we're going to talk about some resources as well. I also want to mention that most of this presentation is really focused on New York State law. When it comes to who can provide immigration-related services, different states have different regulations. So as an example, we're going to use New York State, and most of the presentation will be specifically geared for New York State, and we're going to discuss, in particular in some instances, New York City law. Let me start by just explaining that I'm the attorney in charge, as was previously stated, of the Immigrant Affairs Program with the New York County District Attorney's Office. And the Immigrant Affairs Program, abbreviated as IAP on the slide, essentially the focus of the program is to investigate and prosecute frauds committed against immigrants. Oftentimes immigrants seeking residency or citizenship are often preyed upon by criminals who essentially steal from them by employing a number of fraudulent scams. A lot of the information that we're going to discuss is going to come based upon my experience as the attorney in charge of this program. Next slide, please. So let me tell you a little bit about how the program works. Our program works in a couple of different ways. We operate a hotline, and people can call our hotline, and the number is indicated on the slide. People can visit our office as well as send us a letter. The information in terms of visiting our office or sending us a letter is in our program brochure, and that's going to be part of the resource slide that we're going to discuss at the end of the presentation, of this part of the presentation. Each complaint that's filed with the program is reviewed by myself, and if it's appropriate, I will assign that complaint to another assistant district attorney who will investigate and then prosecute that matter if it's appropriate. Anyone, regardless of immigration status, can contact our program and file a complaint. We do not report victim and witnesses to the federal immigration authorities, and that's very important to emphasize. And we also have court-certified access to court-certified interpreters, so language is not a barrier for us in terms of taking a complaint or meeting with someone. Next slide, please. Since I indicated before that our program operates a hotline, and I also indicated that I review each one of the complaints that come in through the program. And effectively, since December of 2007, our program has processed approximately well over 1,900 complaints. It's very close to 2,000 right now, actually. And I've looked at all these complaints, and essentially what I can tell you about these complaints is essentially, next slide, please, is that approximately 50% of the fraud that is reported to us relates to individuals or immigration service providers who represent themselves to be attorneys or who provide legal advice when they are not licensed attorneys or accredited by the Board of Immigration Appeals. And now my co-presenter, Tom Shea, will, after this part of my presentation, discuss with you what is the BIA and the accreditation process. But essentially, what this information means is that 50% of the fraud that's reported to us relates to the unauthorized practice of law. Next slide, please. So let's talk about then who is authorized to provide immigration legal services. Well, essentially this boils down to, and again I'm going to be very specific and limit this particularly to the state of New York, since when it comes to immigration matters, a lot of things can vary from state to state. So when it comes to here in New York State, only a licensed attorney, licensed in any state of the United States, of course, or an individual who is accredited by the BIA and who works for an organization that is recognized by the BIA can represent an immigrant for payment in connection with an immigration matter or court case. Essentially, this means that if you're not a lawyer or BIA accredited, you can't practice immigration law. So what can non-lawyers do when it comes to the area of immigration? Well, non-lawyers and non-accredited individuals who work for a nominal fee can only essentially provide clerical assistance. So next slide, please. Well, this actually brings us to our first poll question. And let me tell you a little bit about how poll questions work. I'm going to ask you a question, pose you a question, as you can see on the slide right now. And then after I read to you the question, another slide is going to come up that's going to present a couple of different options in terms of answers for you. We're going to go through those possible answers, and then I'm going to give you a minute to choose an answer. And then we're going to discuss and talk about what was the right answer. So let's get started with the first poll question. The question is, generally, who is authorized to provide immigration legal services? Now, you have one of the following choices that you can choose from for an answer. And the first choice is A, lawyers only. The second choice is B, BIA accredited representatives only. Or C, A and B. Or D, none of the above. Once again, let me ask the question again. Generally, who is authorized to provide immigration legal services? And you have the following choices. A, lawyers only. B, BIA accredited representatives only. C, A and B. Or D, none of the above. Go ahead and take a minute to go ahead and put your answers in. Put your answers in. Once again, the question says generally, because some of these things could vary from state to state, but we're focused right now on the state of New York. So let's see, next slide, please. So we have here the results for the poll, and let's see, 88% got the answer right. The answer is C, A and B. As I previously discussed, particularly when it comes to the state of New York, focusing it on the state of New York, only lawyers and BIA accredited representatives can essentially give immigration legal services, provide legal advice. So the answer A would not be correct because it limits it only to lawyers. The answer B is not correct because it limits it only to accredited representatives. And I guess the answer D is not correct because the answer is C, A, and B. So very good job. All right, let's move on to the next slide. So that brings us to what is clerical assistance. So for non-lawyers who want to be involved in providing some type of immigration service, non-lawyers can pretty much, the only thing that they can do is translate, for example, which is a very good service, needed service. They can notarize if authorized, and again, the rules for becoming a notary can vary from state to state, but if you're authorized, you can notarize as well. Can make copies, obviously. You can transcribe. And what this means is important because essentially this means that the client tells the provider what to write in a blank space or form, and then the provider writes down as indicated what the client stated. That's fine as long as you're not giving legal advice or interpreting what should be stated on that form. The non-lawyer can also help obtain birth certificates, make appointments for fingerprinting, for example, and make free referrals to immigration lawyers, BIA accredited organizations, and other resources. Next slide, please. Now let's talk about what is the law in the state of New York that supports all of this in terms of what non-lawyers can do or cannot do. So in the state of New York, if you want to charge a fee for providing clerical services, you must comply with the Immigration Services Provider Law. And in the state of New York, we have two versions of this law, the New York State version, which is part of our general business law book, and we also have the New York City Administrative Code law when it comes to this. These two laws mirror each other and are very similar in most respects, so I'm generally going to discuss what they both require. Now, whether you provide a service for free or charge a fee, you must comply with, in New York State, the Judiciary Law, Section 478, which is essentially our Unauthorized Practice of Law statute. Next slide, please. Let's discuss a little bit about what the general business law as well as the administrative code require. And essentially, they both are a laundry list of prohibited conduct, telling people that essentially if you're a non-lawyer or not BIA accredited, that you essentially cannot give legal advice or practice law. Now, that's very important. And here is where federal regulations come into play, and they help us define what representation is, and in particular what practice of law is. And federal regulations define practice as essentially the act or acts of any person appearing in any case, either in person or through the preparation or filing of any brief or other document, paper application, or petition on behalf of another person or client before the service or the board. And of course, the service refers to the United States Citizenship and Immigration Service, and the board is the Board of Immigration Appeals. So pretty much what this is saying is that you can't, essentially, that if you're helping someone, if you're preparing an immigration form or petition or some other document, that essentially that is considered practice. And that's not allowed if you're not BIA accredited or an attorney. Preparation is also useful here, the definition of preparation, and that's defined as the study of the facts of the case and the applicable laws, coupled with the giving of advice and auxiliary activities, including the incidental preparation of papers. So again, the preparing of immigration forms is part of the practice of immigration law. So next slide, please. So let me give you some examples of what the practice of law and or the giving of legal advice practically is when it comes to immigration legal services. So essentially, anything other than filling out a form as directed by a client may be the practice of law. That includes telling a client what form to fill out, telling a client how to answer questions on the form, telling a client what immigration benefits they may or may not qualify for, telling a client what something on the form means, telling a client whether or not to file a form or application, and speaking on behalf of a client during an immigration interview, for example. All of these things could be considered the practice of law. And I would like to just note that in New York State, under our case law, clearly the practice of law has been defined as the giving of legal advice and the preparation of legal instruments and documents. So again, these practical guidelines are in conformity with New York State law. So continue, please, with the next slide. Then we have here some more of a continuation of the laundry list that essentially the general business law and the administrative code prohibit non-lawyers from doing. And so, for example, no service provider can threaten to report a customer to immigration. no service provider can charge or refer someone, no service provider can charge in order to refer someone to an attorney or an agency. They have to keep original documents. And the most important of these prohibitions, I think particularly, is that these non-lawyers cannot use or advertise the title of lawyer, attorney at law, or any equivalent term, or represent or advertise other titles or credentials, including but not limited to notary public. Of course, the exception are if you are a notary, you can use that title. Accredited representative of the Board of Immigration Appeals or immigration consultant that could cause anyone to believe that the person possesses special professional skills or is authorized to provide advice on an immigration matter. So it's very important not to give the authority, essentially, that this non-lawyer, non-accredited person can in fact practice immigration law when you're not allowed to. Next slide, please. Summary of prohibited conduct. That's essentially another continuation is that you can't use these titles such as notary or immigration consultant, and they're not authorized to give legal advice. Next slide, please. These two laws also require that these non-lawyers or BIA accredited individuals provide contracts to their clients, identifying exactly the service they're going to provide in the language that the customer understands. They have to have signs posted up, visible to the clients, indicating that they're not licensed as attorneys and may not give legal advice. They have to retain documents, and they need to have a surety bond as well. Next slide, please. Now, the Judiciary Law, Section 478, must be complied by everyone here in the state. And this statute pretty much says that if you're not admitted to the bar of the state of New York and you have not taken the constitutional oath, you may not practice law, giving of legal advice and preparation of legal instruments once again. You can't appear in court as an attorney, of course, for a person other than yourself. You can't furnish attorneys or counsel to render legal services. In other words, if you're not a lawyer, you can't own a law practice. You can't hold yourself out to the public as being entitled to the practice of law. So again, these are the prohibitions by the Judiciary Law. Next slide, please. This brings us to our next question. And the next poll question. And in New York State, the question is, in New York State, immigration service providers can only provide, and you have a couple of choices. That's A, legal advice, B, clerical assistance, C, representation, or D, all of the above. Once again, the question is, in the state of New York, immigration service providers can only provide, and you have four possible choices: A, legal advice, B, clerical assistance, C, representation, or D, all of the above. Again, the question is being limited to New York State law. This could vary what an immigration non-lawyer BIA accredited individual could do within that realm. Could vary by state to state. So different states have different regulations around that subject matter. So that's why we're limiting it to the state of New York. And at the end of the presentation, I'll give you resources to find out what the other states say about the issue. So let's see what most of the people answered. Okay. The poll results show that 74% got the answer correct, and that is B, clerical assistance. And clerical assistance is what I was explaining earlier, to be, for example, that you could translate, transcribe, make copies of documents, help obtain birth certificates, and so forth. The other choice was all of the above, which people indicated, and that would not be the right answer because, for example, immigration service providers that are non-lawyer and BIA accredited can't give legal advice. So that is, or represent someone, as that term is defined by federal regulation. Only BIA accredited individuals and lawyers can provide representation. So that brings us to our next slide. Why is all of this important? Well, essentially, the consequences of filing for an immigration benefit when the immigrant does not qualify for that benefit can be deportation. Therefore, it's important to hire a person who has the right training and skills. And I want to emphasize that this is very, very important, particularly for people who may be facing the deportation proceeding. Immigration deportation defense is a very complicated area of law that requires a lot of training and skill. So it's very important when the consequences are so huge. It's very important that the person receives appropriate counsel and advice before filing any immigration documentation or application. Now, it's also important to know that if you hire someone to help you with an immigration matter who is licensed or BIA accredited, then that person could be subject to discipline. And in the state of New York, for example, immigrants can file complaints with disciplinary committees against lawyers. So it's important to have that check and balance as well in terms of making sure that the person who is representing you in connection with the immigration proceeding, that there's some other recourse avenue other than filing a complaint in my office. So next slide, please. Let me go into now in terms of talking a little bit of crime prevention tips. And this is very important because, as I stated before, since our program has been operating, we've received almost nearly at this point 2,000 complaints. And so it's important for people to really take this to heart, particularly for recent immigrants. And that is to obtain the full name, address, and telephone number of the person being hired. If you're scammed or wrong, having the person's names or contact information will make it much easier to investigate and locate that person. And I'm stating this, and this may be obvious to some of us, but if you come from a different country where things and businesses can be operated or conducted in different ways, this may not be so obvious. So please encourage everyone to do that. And if someone doesn't want to give you their full name, then you really have to ask yourself, why is that? And it could very well be so that they won't be tied to the crime. So it's very important to do that. Next slide, please. It's also then very important to make sure that the person you're going to hire to help you with an immigration matter has the right credentials to do so. So you want to ask the person, are you licensed as an attorney? What are your credentials? And if you're licensed, in what state are you licensed and since when? So that way you can make sure that the person has a sufficient amount of experience in the field that essentially will help you essentially be successful in your matter. So then you want to confirm that the person is actually an attorney or BIA accredited, and to learn or confirm whether an individual is a licensed attorney or BIA accredited, you can look at our brochure, and at the end of the presentation I'm going to provide a link to our brochure where you can check that information. Next slide, please. Finally, all victims are strongly encouraged to contact our program, and our hotline number is indicated on the slide, and here is the address or the link for our brochure where you could get more tips, because there's a lot of tips in this area for people to really keep in mind. But in interest of time, I've limited to what I previously stated. Really, this is an area where we all really need to work together to make sure that justice is accomplished. So thank you for this opportunity, and I now want to point out other resources for people outside of the state of New York when it comes to finding out what the different regulations could be for non-lawyers and non-accredited individuals to do anything when it comes to the immigration service area. And here's a link to the American Bar Association, their Commission on Immigration. They really have a vast amount of information when it comes to this issue. And I hope this information and all of the other information that I've provided to you is useful. Thank you very much for giving me this opportunity. And I now turn it over to my colleague, Tom Shea.
Great. Thank you, Daisy. And I wanted to start out. My name is Tom Shea. I'm the Director of Training and Technical Assistance for the New York Immigration Coalition. And I wanted to thank CUNY Citizenship Now and the CUNY School of Professional Studies for inviting me to come speak today. And I wanted to thank Daisy for giving such a very clear and great presentation on the Unauthorized Practice of Law. And I wanted to pull two items out of Daisy's presentation to start out mine. It's very important that if people are going to be engaging in the practice of law, that they either be a licensed attorney in the United States and in good standing, or that they be an accredited representative with a Board of Immigration Appeals recognized agency. So my presentation today will be general information on what BIA recognition and BIA accreditation are. And again, this information will be general information. It's not specific legal advice on how you should seek recognition for your organization or seek accreditation for yourself. Next slide, please. So what is the Board of Immigration Appeals? It is the federal appellate administrative court for immigration law in the United States. It's part of the Executive Office for Immigration Review, which in turn is part of the United States Department of Justice. The Executive Office for Immigration Review is an umbrella organization in the United States for all the immigration courts and the Board of Immigration Appeals. So if you have a client who is in removal proceedings before an immigration judge, the decision by the immigration judge can be appealed to the Board of Immigration Appeals, the BIA. But the BIA also has authority to recognize certain nonprofit organizations as being authorized to provide immigration legal services, and as well as have the authority to accredit certain staff of those BIA recognized agencies to provide the legal services. Next slide, please. So recognition refers to the nonprofit organization, and accreditation refers to the specific staff, the individual staff who are being authorized to provide the immigration legal services for the recognized agency. So accredited representatives may then practice immigration law just as an attorney would before the Department of Homeland Security or before the Department of Homeland Security and the Executive Office for Immigration Review. Next slide. Accredited representatives may practice immigration law only at the recognized agency that applied for her or his accreditation. The accredited representatives may only do immigration work under the auspices of that recognized agency at the site, the physical site that applied for the accreditation. Next slide, please. So BIA recognition pertains only to nonprofit organizations. The agency must have recognition in order for the agency's staff to be accredited by the BIA. Only recognized nonprofits may apply for staff members to become accredited. So a person cannot apply for accreditation on their own. The person has to be a staff or be affiliated with the nonprofit organization in order for the organization to apply for accreditation on behalf of the staff. Next slide, please. So the criteria for recognition. The organization must show that it's a nonprofit religious, charitable, or social service agency, or any combination of the above, that the agency charges only nominal fees, and I'll get into that a little bit more later, and that the agency has knowledge of and experience with immigration law, including maintaining an immigration resource library. And I provide some citations to the regulations for you, to the 8 Code of Federal Regulations, 8 CFR. Next slide, please. So the duration of recognition. Once a nonprofit organization is recognized by the Board of Immigration Appeals as being authorized to provide immigration legal services, that recognition lasts indefinitely. So you don't have to apply for recognition again at a later point. The BIA could, however, at a later point, revoke that recognition if they find out that the organization no longer meets the requirements for recognition. If the agency changes names, it needs to let the BIA know so that it can update its roster of recognized organizations. You can find a roster of recognized organizations on the website for the Executive Office for Immigration Review, and I provide the link to it there in the slide. Next slide, please. And once again, recognition is site-specific. So if your agency has more than one physical site and you would like to offer immigration legal services at more than one site, each site needs to apply separately for recognition, even though the sites are part of the same overall agency. Next slide, please. So the accreditation rules for staff are laid out in the 8 Code of Federal Regulations. I provide the citation there. For individual staff members working at a recognized agency, once again, you cannot get accreditation if you work on your own, if you're working as an individual, and you cannot get accreditation if you work for a for-profit organization. The agency, the nonprofit agency that is recognized, applies for accreditation on behalf of the staff, or if the nonprofit agency is seeking recognition, it can simultaneously apply for accreditation on behalf of the staff person. And again, the accreditation is specific to the agency. So for example, if Anna is accredited at agency A and then leaves to work at agency B, she would no longer be accredited, and agency B would have to reapply for her, provided that agency B was also a recognized agency. Now remember, accredited representatives may be part-time workers and may be consultants or volunteers with the nonprofit recognized agency. Next slide, please. There are 2 levels of accreditation. Partial accreditation allows practice before the Department of Homeland Security only. You may do everything an attorney would do before the Department of Homeland Security while working for the BIA recognized agency. You couldn't hold yourself out as an attorney, though. And then there's full accreditation, which allows the accredited representative to represent people not only before the Department of Homeland Security, but also before the Executive Office for Immigration Review, meaning, once again, the immigration courts and the BIA. Next slide, please. BIA accreditation lasts for 3 years. You must renew it at the end of 3 years, and you have to file the application to renew your accreditation at least 60 days before the expiration of your accreditation. During that 3-year period, the accredited representative must continue to obtain legal education or training in immigration law to maintain their knowledge of immigration law. It's helpful to the renewal application for accreditation. And once again, that accreditation is specific to the agency, so if the staff person leaves the agency, they lose their accreditation. Next slide, please. So there are still, if an agency has accredited representatives, other staff may work with them on immigration matters, but they have to do it under the direct supervision of the accredited representative. The accredited representative must supervise the non-accredited staff, and only accredited representatives may sign the Form G28 and accompany clients to interviews. The Form G28 is the Notice of Entry of Appearance as an attorney or accredited representative before the Department of Homeland Security. So that's essentially the notice to the Department of Homeland Security that there's a legal representative on record in the case. So non-accredited representatives cannot file G28s with the Department of Homeland Security. Or more accurately said, they are not authorized to file G28s with the Department of Homeland Security. And non-accredited staff working with accredited representatives would be like paralegals. Next slide, please. I should go on to the next slide. Next slide, too. Thanks. So the criteria for BIA recognition of a nonprofit agency. It has to be a nonprofit religious, charitable, or social services agency, and it can be any combination of that. It must charge only nominal fees for the legal services that it provides, and it must demonstrate to the Board of Immigration Appeals that it has knowledge of and experience with immigration law, including maintaining an immigration resources library. In other words, in your application for BIA recognition, it is your responsibility to demonstrate to the BIA that you know what you're doing, that you have the knowledge and or experience in immigration law to provide legal advice and to represent people either before the Department of Homeland Security or to represent people before the Department of Homeland Security and the Executive Office for Immigration Review. Next slide, please. The application form for BIA recognition is the form EOIR 31, and I provide the link to you there where you can access it on the EOIR website. There's also the instructions to that form, as well as Board of Immigration Appeals case law that provides guidance on applying for BIA recognition and some of the standards that must be met to apply for BIA recognition. And you'll be able to find a list of some of the precedent decisions on BIA recognition and accreditation on the website after this presentation. I submitted a list of cases that people could access after the training. Next slide, please. How would the organization show nonprofit status as part of the application? They provide a copy of a certificate of incorporation as a nonprofit. They also provide a copy of their bylaws, a copy of their 501c3 status letter from the Internal Revenue Service, IRS, and they must indicate on the form EOIR 31, is one of the questions that they have to respond to, whether the agency is a religious, charitable, or social service agency, or a combination of them. Next slide, please. Now to the issue of nominal fees. There is no definition specifically of nominal fee in the statute or in the regulations. Although by practice, is my experience, that if fees provide more than 50% of the funding for your immigration program, generally the BIA tends to deny, because the idea of a nominal fee, and I provide a citation to American Paralegal Academy, is that nominal fees are supposed to be not actual fees or real fees. It's something in name only, and it's supposed to be because you are representing low-income or indigent people, so you shouldn't be making a profit for your organization on fees. So therefore, and I know this isn't clear guidance on it, there just isn't any specific definition of nominal fees. The idea is that for a nonprofit organization, you are representing people who are low-income or indigent and therefore can't afford to be paying high fees. The fact that you pay less than private attorneys in the area in and of itself is not enough to prove that you're charging only nominal fees. It might be worthwhile for your organization to look at other or reach out to other BIA recognized agencies in your area to find out what they're charging for immigration legal services to get an idea of what would be acceptable fees. When you're applying for BIA recognition, you must submit a list of fees as well as a list of the services, the immigration legal services that you would provide. And it's very important to also include, as a separate attachment, a list of the funding for your nonprofit organization. Since you can't rely on fees to make a profit for your organization, you shouldn't be making a profit for a nonprofit organization. You have to demonstrate how your organization is able to maintain operation. So in other words, the funding comes from other areas, for example, federal funding or private foundation funding or maybe state or city funding for your organization. Next slide, please. So the fee schedule, it lists the fees for each service you plan to provide. It's a required part of the recognition application. It's very important on that fee schedule to include a statement to the effect of no one will be denied services based on an inability to pay. The BIA would be looking for something like this. It might be also worthwhile to include in the application, if you have this policy, a written fee reduction or a fee waiver policy that your organization has, or a written policy on sliding fees. Next slide, please. Now, the statement of agency funding, it could be a bare-bones list of every source of funding the agency gets for the year. For each source, list the total amount the agency receives for the year. And this gets to be one page for the whole list. And you should also include an estimation of how much you expect the immigration program would bring in per year. Next slide, please. So how does the organization show adequate knowledge, information, and experience of immigration law in order to obtain a recognition for the organization? You should include the resume of each staff who is seeking immigration BIA accreditation. If you already have an immigration attorney on staff and you're not seeking and therefore are not seeking accreditation for another staff member, you would at a minimum submit the resume of that immigration attorney. You would also submit a list of your library resources that indicate all the immigration legal resources that you have, whether in print or on the web. Mention also any connections that the agency has with immigration attorneys and or BIA accredited representatives outside of the agency. Now, note that this is not mandatory for recognition unless you do not have an attorney or a fully accredited representative on staff and you are applying for partial accreditation for a staff person. So if your organization is applying for recognition and you do not have an immigration attorney on staff, you could simultaneously, or you must simultaneously, either apply for full accreditation on behalf of one staff person, or you can apply for partial accreditation on behalf of another staff person, but with partial accreditation, you would have to demonstrate to the BIA that that partially accredited representative would have access to additional expertise, which could be some sort of relationship, mentoring relationship or technical assistance relationship with an immigration attorney outside of the organization or with an accredited representative with another organization. Next slide, please. So it brings us to our first poll question. True or false? When applying for BIA recognition, you must have an immigration attorney on staff. Choose the best answer. So I'll just restate the question. True or false? When applying for BIA recognition, you must have an immigration attorney on staff. Select one of the following. A, true. An agency must have an attorney on staff. B, false. An agency can apply for full staff accreditation. Or C, false. An agency can apply for partial staff accreditation. Or D, either, B or C. So while we're taking a moment to have people respond to the survey, I just want to mention a little bit about the work that the New York Immigration Coalition does. We're a nonprofit organization that serves as an umbrella for approximately 200 organizational members throughout New York State, and we provide policy and advocacy assistance to these organizations on a New York City level, on a New York State level, and on certain issues on a federal level, on issues that impact immigrants. For example, immigrant access to health care, immigrant access to public education, immigrant access to housing, and comprehensive immigration reform. And in my role as the Director of Training and Technical Assistance, I run a continuing legal education, a CLE immigration training program, the Immigrant Concerns Training Institute. And with that, I'm going to go back to the question, and just the question once again is true or false. When applying for BIA recognition, you must have an immigration attorney on staff. Choose the best answer. And A being true, an agency can't be recognized without an attorney on staff. Or B, false, an agency can apply for full staff accreditation. Or C, false, an agency can apply for partial staff accreditation at the same time. Or D, either B or C. And the answer is D, either B or C. So if an agency does not have an attorney on staff when they're seeking BIA recognition, they can simultaneously apply for full accreditation on behalf of a staff person, if that staff person qualifies for full accreditation, or they can, when they're applying for BIA recognition, they can simultaneously apply for partial staff accreditation if they demonstrate that that partially accredited representative has access to outside expertise. All right, move on to the next slide. So as part of the BIA recognition application, you have to include a list of your library resources because the BIA wants to see that you have access to immigration law resources. So at a minimum, you have to have an up-to-date copy of the Immigration Nationality Act, the statute, the INA, as well as an up-to-date copy of the regulations, the 8 Code of Federal Regulations at a minimum. Remember, you can also access these for free online through the United States Citizenship and Immigration Services, USCIS website, or through the Executive Office for Immigration Review website. Also include legal resources, other legal resources that you can access online. For example, as I just mentioned, the USCIS website provides a lot of other helpful information, as well as the Executive Office for Immigration Review website. And other information you could obtain through the U.S. Immigration and Customs Enforcement website, or the U.S. Customs and Border Protection website, or the United States Department of State website. You might consider other organizations that provide helpful legal resources or information on immigration law, such as Bender's Daily Immigration Bulletin. And so it's just important to note that you can have printed material in your library as well as online legal resources. Next slide, please. They also strongly recommend that you have secondary immigration legal resources. An example that we provide here is Kurzban's Immigration Law Sourcebook, which I think is a great legal resource. Depending on what services, immigration legal services, your organization will focus on, you would also want to have manuals on those particular topics. For example, some organizations will focus on naturalization work. You want to make sure that you have manuals on naturalization and citizenship in your legal services law library. You want to indicate also any membership in professional associations. For example, if your organization is a member of the New York Immigration Coalition, or a member of the CUNY Citizenship Now Network, or a member of the American Immigration Lawyers Association, AILA, or a member of the National Immigration Project, for example. Next slide. Next slide. So just what to include in the actual packet for BIA recognition. You want to have the form EOIR 31, it's the application for recognition. And just so you know, there is no fee to file an application for BIA recognition, to file that form EOIR 31. The most important part of the application for recognition will be that cover letter. And the cover letter will come from the executive director of the nonprofit organization, or it will come maybe from your chair of your board of directors, on the letterhead of the organization. You have to provide proof of your nonprofit status, a list of the immigration legal resources. You have to include the fee schedule, a list of the funding sources for your organization so the BIA can see how your organization can continue to operate. You have to include an organizational chart showing the supervision of the immigration staff. The BIA will want to see who is supervising the provision of the immigration legal services. You must also include letters of support from people, both letters of support for the application for recognition and letters of support for the applications for BIA accreditation. Next slide, please. The form EOIR 31 is fairly straightforward, very easy to fill out, doesn't take that long, and the instructions are pretty straightforward. Next slide. Now, as part of your cover letter, the executive director of your organization really needs to introduce the organization to the Board of Immigration Appeals. This doesn't have to be a very lengthy letter. It's just that you're explaining to the BIA what your organization is, how long your organization has been around, the services that your organization has been providing to the community, and why now your organization wants to start providing immigration legal services to the community, and most importantly, how you now have the knowledge and experience to provide those immigration legal services to the community that you serve. All right, next slide, please. Next slide, please. I'm going to skip over some slides here. I'm providing them more as a resource for the people participating in this webinar, but it's information that I just mentioned earlier, but it's provided for you as a resource for after the training. So, next slide, please. Next slide, please. And the next slide. All right, just for the organizational chart, which is very important. It doesn't really get into much detail about this in the instructions on the form EOIR 31, but the chart of agency personnel showing which positions supervise other positions, and it should indicate who will supervise the immigration staff, because they want to make sure that whoever is providing the immigration legal services is being supervised by someone who knows what they're doing, who knows the immigration law. Next slide, please. So the letters of support or recommendation letters from other local agencies that know your agency's work and can attest to the good work that you do and the importance of your being able to offer immigration legal services in your community. I recommend that the letters be from people who have firsthand knowledge of the services that your organization provides. It'd be great if the letter of recommendation comes from an outside immigration attorney or another immigration attorney who can speak to the services that your staff have provided. Once again, just as a reminder, if your organization is seeking BIA recognition and you don't already have an attorney on staff, when you seek recognition, either you must simultaneously apply for full accreditation on behalf of a staff person, or you must apply for partial accreditation, and for partial accreditation you must demonstrate that that partially accredited representative has access to outside expertise, which in practice most likely means some sort of relationship with an immigration attorney or another BIA-recognized agency. Next slide, please. Also, as part of the application, if you have them, it's good to include good articles, newspaper articles that speak to the services your organization provides. Next slide, please. I provide some information about where the application can be mailed to, or should be mailed to, but that information is also on the form EOIR 31. I also provide the telephone number, so if you have questions about the BIA recognition process, you can call the Board of Immigration Appeals yourself, and that's the telephone number. Next slide, please. When you file an application for BIA recognition, you must file a copy of the application, one copy with the District Director of the USCIS and one copy with the ICE Office of Chief Counsel in your area. And then you must provide proof of service with your original application to the BIA. The proof of service meaning you're proving to the BIA that you served a copy on the USCIS and a copy on the ICE Chief Counsel. Next slide, please. Now, these next two slides are really just information specific to New York, so this isn't relevant to people outside of New York. So we'll just skip these next slide, thanks. And next slide. Thanks. Now, that information I just provided was primarily about the application for BIA recognition. Now I'm going to get into a little bit about application for accreditation. Next slide, please. Now, just so you know, there's no application form for an organization to apply for accreditation on behalf of a staff person. You would submit the application packet. The application for accreditation and the application for recognition would be submitted together. Unless your organization is already recognized, then it could, if you're applying for accreditation at a later point, it would just be an individual application for accreditation. Now, the regulations require that candidates for accreditation have experience and knowledge of immigration and naturalization law, and that they be people of good moral character. Once again, it's the agency that applies for accreditation on behalf of the individual, and it would have to specify in the application for accreditation if it's seeking partial accreditation for the staff or full accreditation. They have to be explicit about that in the application. Now, once again, the partial accreditation refers to representing people before the Department of Homeland Security only, and full accreditation refers to representing people before the Department of Homeland Security as well as the Executive Office for Immigration Review. Now, it is BIA-recognized agencies can choose which immigration legal services they are going to provide. They don't have to provide the whole range of immigration legal services. But you're going to indicate in your application for BIA recognition that which services your organization is going to be providing. That'll be on the list of services and the list of fees, because the fees will be tied to which services you provide. Now, just so you know, applying for BIA partial accreditation is generally easier than applying for BIA full accreditation because the BIA is looking for more training for people who are going to seek full accreditation, because full accreditation permits you to represent people before the Immigration Court and the Board of Immigration Appeals. Can you go to the next slide? Because full accreditation allows people to represent foreign nationals before the Immigration Court and the BIA is going to be looking for people who can think on their feet, who can give oral arguments, who can write briefs and conduct direct examination and conduct cross-examination and can give opening statements and closing statements. So they're looking, which requires a higher level of training than people who are seeking partial accreditation. Next slide, please. Once again, someone seeking partial accreditation has to work for a BIA-recognized agency. The application for accreditation must demonstrate to the BIA that the staff person seeking accreditation has knowledge of and experience with immigration law. And that's generally demonstrated by the resume of the staff person, as well as copies of either the agenda from training programs or maybe letters, certificates of attendance at training programs. The application for accreditation must also explicitly state that the staff person seeking accreditation is a person of good moral character. Next slide, please. And staff will need training on immigration law and procedure to fulfill this knowledge and experience requirement. The regulations don't specify how much training is required. There's no formula for exactly how much training staff members need. Generally, I always recommend that someone seeking accreditation first have at least 40 hours of substantive immigration law training under their belt before they file that application. Once a person does obtain accreditation, they still need ongoing training to make sure that they maintain up to speed in immigration law. If you have worked under the supervision of an immigration attorney, that should also be included in it should be reflected in your application for accreditation. Next slide, please. Let's provide some links here to organizations that provide trainings on immigration law. Now, for that bottom bullet, you'd focus on topics that will be the most relevant to the services that the agency wants to offer. That is true, but you just want to make sure that the accredited representative has a broad background, a broad training in immigration law, because even though they might focus just on naturalization law, they still need to know other areas of immigration law. So when they're screening a case, they'd be able to appropriately refer people to immigration attorneys for services that are outside of their area of expertise. For example, if I'm doing naturalization work, I would still need training on the Violence Against Women Act or training on the immigration consequences of criminal behavior, so that if I encounter these issues and I can't help someone with naturalization, I can refer them to agencies that can help with VAWA or help with the immigration consequences of criminal behavior. So you need a broad training in immigration law, even if you're only going to focus in one area. Next slide. Brings us to our poll question. Maria, a college graduate with a Bachelor of Arts in Economics and a minor in pre-law, works for a BIA-recognized agency and is preparing to obtain BIA accreditation. She has no background whatsoever in immigration law. What education must she demonstrate to the BIA in order to obtain BIA accreditation? So I'll restate the question. What education must she demonstrate to the BIA in order to obtain BIA accreditation? You would select one of the following. A, her Bachelor of Arts and minor is enough to obtain accreditation. Or B, the regulations provide no guidance regarding the education level. Or C, regulations require 40 hours of immigration law training. Or D, recommend 40 hours of immigration law training. Or E, both B and D. So we'll take a moment to allow people to respond to that poll question. And it's because this is, I threw this question out there because this is the question that always comes up in all the trainings, and it's very important for people to have a good understanding that there's not a lot of guidance out there on this, but you still want to do the best of your ability in your application to the BIA, and you still want to make sure that when you're presenting your application to the BIA, you're demonstrating to the BIA that the staff know what they are doing, that they have the knowledge and understanding of immigration law in order to represent people before either the DHS or the Executive Office for Immigration Review, or both. So with that, I mean, we'll go to the survey results now. I guess they're ready. And what education must she demonstrate to the BIA in order to obtain BIA accreditation? We'll go down to, the answer is E, both B and D. The regulations provide no guidance on the education level required, but we generally recommend that someone seeking accreditation have at least 40 hours of immigration law training before they file that application. So I can see that 58% of the people got that right. So we'll move on to the next slide. So for accreditation, the duration of accreditation is only for 3 years. You have to file an application to renew your accreditation at least 60 days before the expiration of that accreditation. And in that 3-year period, before you seek renewal of your accreditation, you must continue to participate in trainings in order to maintain your understanding of the immigration law, because there's often so many changes in the regulations or in policy. Next slide, please. Next slide, please. What should be included in the application for accreditation? As I mentioned earlier, you have to include the resume of staff members who are seeking accreditation, listing all the immigration-related experience, as well as hopefully certificates of attendance at immigration law trainings or the agenda of those trainings. You should have at least 2 letters of recommendation from either the supervisor who knows the person's work or other people who can have firsthand knowledge of the person's work. And once again, you must include proof of service of the application for accreditation to the BIA, and as proof of service that you provided 1 photocopy of the accreditation application to the CIS district office and 1 copy of the accreditation application to the ICE Office of Chief Counsel. And an example of a proof of service is on the back of the form EOIR 31. Next slide, please. So what happens next? Generally, the BIA will wait 30 days because they'll wait for a response. The USCIS and the US ICE have 30 days to make a comment on the application. The BIA is the one that makes the decision on the application, so it's not the CIS or the ICE who make the decision. So whatever they say about the application isn't determinative. And very often the CIS and the ICE don't make any comment. So after 30 days, if there's no comment by CIS or ICE, the BIA will proceed to decide the application for accreditation and the application for recognition. And generally, as it stands right now, I understand the processing is about 90 days from the date you file the application for recognition or you file the application for accreditation till the date of a decision on the case. If the CIS or the ICE were to issue some comments, you would be given time to respond to them. And then the last slide, the next slide, is you would receive a written decision from the BIA, and if they deny your application for recognition or your application for accreditation, they're supposed to explain the reasons why, and then you would be able to turn around and apply for BIA recognition and or accreditation again, as long as you address the issues that were the cause of the first denial. If the letter is a grant, then the staff person can, on that day moving forward, can provide immigration legal services as either a partially accredited representative or a full accredited representative. And with that, I'll end my presentation there.
Thank you so much, Tom. I want to thank Tom and Daisy for being with us again today for their really thorough presentation. And we are going to start the question and answer period now. So I will turn it over to Daisy, who has our first question.
Okay. Well, the first question that I received is essentially asking me to clarify what is clerical assistance. And I'm happy to do that. And essentially, clerical assistance, it really boils down to the following. You can translate. You can notarize if you're authorized within the state that you work. You can make copies of documents or anything. You can transcribe information onto a form. And the question was very specific in terms of what specifically is clerical assistance when it comes to a form. So I'm going to go back to translate and transcribe in a minute. But part of clerical assistance can also include, for example, helping people to obtain birth certificates, helping people to make appointments for fingerprinting, or giving people referrals for immigration lawyers or BIA accredited representatives, for example. That is not a complete and exhaustive list, but is rather just meant to give an example as to what could be permissible clerical assistance. When it comes to filling out the form, or what kind of clerical assistance can be provided in connection with filling out immigration forms, well, that really boils down to either translating information on the form. And when I say translating, I mean translating. That's without interpreting the information on the form, but rather just restating the information in the language that the person can understand. Or transcribing information, which means that a person is giving you an answer, and then you're writing in the form what the person is telling you. Again, without interpreting what the person should say or should not say in the form. And so if you are in the business of helping people with immigration forms, you can only do that to the extent that you're not giving them legal advice. And once you start interpreting the information on the form or telling people what to say on the form, you're giving them legal advice, because the form is a legal instrument. This form affects someone's right and interests. So it's very important. I'm happy that this question was asked, and I hope that this gives further clarification on the issue. The second question that I'm going to attempt to answer at this point is as follows. I was asked the question of, if you're admitted to the practice of law outside of the state of New York, can you practice immigration law in New York if you're not admitted in the state of New York, but you're admitted in another state? And essentially, this is not giving legal advice, or I would like to preface this. This is not giving legal advice, but essentially, if you look at the full statute of the Judiciary Code, Section 478, the statute does not exempt someone practicing immigration law. It does not say that someone who's admitted in another state can come to New York to practice immigration law. There's no exception for such a person. So essentially, if you haven't waived into the state of New York, then essentially, you know, the statute does not exempt you. However, for practicality purposes, I do know, and my understanding is from research that I've conducted and the people that I've spoken to, that for practicality purposes, a lawyer who's admitted in another state can operate a law office in the state of New York that's limited to immigration law. The people who have the authority to prosecute lawyers here in the state of New York do essentially allow that. So So take that with a grain of salt. The statute does not provide an exception, but as a matter of practical purpose, now lawyers admitted in other states can operate a law office solely for the purposes of immigration within New York. Thank you. Now turn it over to Tom.
Right. I just want to thank you, Daisy. It's Patricia. I just want to point one thing add to the answer to that question. Just to add to what Daisy said, what you should do if you're interested in practicing in one state and you're licensed in another is you should check the rules of the state where you're going to practice. So, for example, the bar rules might say that if you're going to practice in one area, that you should advise in all communications that you're limiting your practice to immigration and nationality law. So if you're in the situation that Daisy just discussed, that you're licensed in one state but practicing in another, check the bar rules as far as what the specific rules are. And Daisy did mention this, but I want to just reiterate that, you know, the presenters have really given a lot of their time today, and they're reviewing your questions, but just to know that they're not giving you specific legal advice. They are answering general questions. So if you do have specific legal advice, you should seek legal representation. And I'm going to hand it over to Tom now, who's going to go over 2 other questions. Tom?
Let me jump in for a second, Tom. Patricia, thank you so much for further expanding on my answer, because that is completely correct. The rules do change from state to state, and that's why it's so important to check in with the bar for that particular state if you're in that situation. So like I stated before, the Judiciary Law statute here does not have an exception for that purpose, but if you contact the Bar Association, they'll be able to tell you what to do and to what extent you can advertise, and how we should represent to people that your practice is limited for the purpose of immigration law. Thank you.
Thanks, Daisy. My first question here is, can an agency outside of the United States be recognized by the Board of Immigration Appeals? And I believe the answer to that is no. I believe in order to obtain BIA recognition, the organization has to be located inside the United States. And then I have the second question here is, how can nominal fees be calculated? And which is a great question, and this is the $64,000 question. Because nominal fees are not, or the term nominal fees is not defined in the statute or the regulations, there's very little guidance on what nominal fees are. And as I was trying to explain previously, the concept of nominal fees is that a BIA recognized organization can charge a fee in the sense of name only. It shouldn't be a substantive fee. And it might be worthwhile, if you're trying to calculate fees, a nominal fee for the services that you provide, it might be worthwhile to reach out to other BIA recognized agencies in your area. So they've already gone through the nominal fee process with the BIA and have had their fees approved by the BIA. That's one process. Another process is to sit down and cost out each immigration legal service that you're providing based on the salary of the staff who will be providing that service. And also look at for your funding for the year, look at the total funding during the year versus the fees that you're charging, and verify that the fees that you're bringing in are not going over more than, I would say, be concerned if they're going over more than 40% of your operating revenue. And with that, I know it gets very complicated. You may have to reduce fees if you're charging too much at this point, or if you're not charging fees yet, you basically want to make sure that you determine that the percentage of total fees that you expect to come in would be under that 40% mark. And again, none of this is in the statute. None of this for like that 40% mark or going over the 50% mark, as I mentioned before. That's not in the statute or regulations either. I'm saying this based on my experience helping organizations apply for BIA recognition and accreditation.
Well, thank you, Tom. And I think we're done with the questions. And we want to thank the audience for submitting those questions. If we could have the next slide. I want to tell everyone that within a week you'll receive an email with instructions how to access this web seminar, and we will have the actual seminar and the presentation and also additional resources that the presenters will provide on the Citizenship Now website. So you'll get an email from CUNY, and you can look for that to be up on the website in about a week's time. We can have the next slide. There's a bunch of people we'd like to acknowledge, which are listed here. We can have the next slide. So this will conclude our webinar today on the unauthorized practice of law. Again, I want to thank Tom Shea and Daisy Mejia for taking time out of the busy schedule that they have and the great work they do for the immigrant community and being here with us today. CUNY really appreciates their time and their thorough presentation. We want to thank all of you for joining us today. Please continue to join us for these webinar series. Tell your colleagues, and noting that the series is free. Our next webinar will be next month, and it will be on U visas. That's the letter U, which are victims of crimes. So please join us. If you have any questions about the webinar series, about either of the sponsors of CUNY, SPS, or Citizenship Now, feel free to send me an email. I've provided that on the screen for you. It's pawonder123@yahoo.com. And that's the end of the presentation today, and I want to thank you for joining us. Have a great afternoon and a great holiday.